I was in law school during the recession, and the job that I wanted, which was with the IRS, that's what I was going for. I was already a CPA, went to law school, and I was planning to start working for the IRS. They pulled their funding, it became unavailable. And so I talked to a couple of tax professors, and they said, why don't you go look at Big Four accounting firms? They do a good job of hiring both accountants and lawyers because there's a good mix of work. And so I ended up getting on with Ernst Young in their tax-exempt organization group. At the time, I knew generally what a nonprofit was, but I had no idea how deep this field of knowledge was. And so I kind of cut my teeth working there for about 6-7 years. We worked on some of the largest foundations and charities in the nation and saw basically every complex issue that you could imagine.
You're listening to the Nonprofit Counsel podcast with host May Harris.
Welcome to the Nonprofit Counsel podcast. I'm May Harris, and today I am joined by Mike Payne, who is the founder and CEO of Boss Advisors, a really innovative firm that does a lot of work with nonprofits. So I am so excited to have him as a guest on the Nonprofit Counsel podcast. Welcome to the podcast, Mike.
Thank you so much for having me, May. It's great to be here.
Well, my pleasure. I was very excited to have you on because you really have some innovative things going on with Boss Advisors. Maybe you could start by just telling everyone a little bit about what you do and how you got into the nonprofit sector and advising the nonprofit sector.
Yeah, so total accident. I didn't mean to get in the nonprofit sector. What happened was I was in law school during the recession, and the job that I wanted, which was with the IRS, that's what I was going for. I was already a CPA, went to law school, and I was planning to start working for the IRS. They pulled their funding, it became unavailable. And so I talked to a couple of tax professors, and they said, why don't you go look at Big Four accounting firms? They do a good job of hiring both accountants and lawyers because there's a good mix of work. And so I ended up getting on with Ernst Young in their tax-exempt organization group. At the time, I knew generally what a nonprofit was, but I had no idea how deep this field of knowledge was. And so I kind of cut my teeth working there for about 6-7 years. We worked on some of the largest foundations and charities in the nation and saw basically every complex issue that you could imagine. Had a lot of interactions with the IRS, state departments of revenue, AGs, and then eventually, after that 6-7 years, I decided I wanted to branch out on my own, and so I started Boss Advisors. Just as a solo, I actually started a law firm and a CPA firm. And then eventually Arizona changed the rules, which allowed me to combine those firms. And so that's where we are today. We are a all-in-one kind of one-stop shop. We provide legal, tax, accounting to nonprofits and to for-profit businesses.
Right. You don't focus solely on nonprofits, but it's a significant part of your practice group.
I have two of my team members. One, they were both with me at Ernst Young. One is a nonprofit CPA, one's a nonprofit lawyer. All they do is nonprofits. My personal time, I kind of split between running the firm, for-profit clients, and nonprofits. So kind of a more generalist, whereas they're complete specialists.
Right. So when you mentioned, going from law school with the intent to work at the IRS, was that in exempt organizations or was it just to work for the IRS?
No, I was actually planning to was hoping to be in general counsel. Mm-hmm. So you actually be in tax court and litigate. And I didn't know what a special area what nonprofits were at the time. Right. I'm so glad I fell into this area. It happened to be, the job that was available for me. And so I jumped in, and fortunately at the time, there was an opportunity to work with the managing partner who happened to sit here in Phoenix where I live. And so I got to work one-on-one with him, and I just learned so much during that time.
Well, and I think you said it in a nutshell. I mean, you intended to be a tax practitioner. You had a CPA, you had your JD, and you didn't even really know about exempt organizations, law, or tax. It's not typically taught in law school. It's not, shouted far and wide that it's such an amazing practice area. So you're not the first person I've spoken with who fell into this by chance.
Yeah, I'm not aware of any formal training in law school or my undergraduate accounting degree. Outside of there was a portion of one class was about fund accounting in undergrad, and then in law school it was like a topic that was touched within one of our tax courses, but there was nothing in depth that I'm aware of. Maybe some schools, have programs for nonprofits, but really it's one of those areas where you have to seek additional education after your higher education. You have to learn on the job. You've got to learn from, your service on the board and other things.
Right. I've only really discovered a couple of law schools that even remotely focus on it. I think it's Georgetown. Loyola has some. USD, actually, where I went to law school, has one, but it's an elective and they only run it if there's enough interest. And for whatever reason, there's never enough interest. And it actually baffles me because it's such a robust, and I think it's a fascinating area of law. It always surprises me how few practitioners actually know about it, much less, that's their goal.
Well, I love it because for me, it's a perfect mix of law and accounting, or law and tax, really. Mm-hmm. It's kind of the intersection of law and tax. And that's because for nonprofits, so many of the governing rules that they have to abide by come from the Internal Revenue Code. And that's a unique area where, when I was at the big firm, half the people we hired were lawyers and half were CPAs. Mm-hmm. And that's just how it goes, because it's not a computational form. The 990 is, there's some pieces of it that are, computational, but at the end of the day, the disclosures and the narratives matter so much that you really have to have somebody who, is a good writer and understands procedure and theory instead of just the numbers like you would with a traditional business return. Absolutely.
I mean, the IRS terms it an informational tax return, not like a tax return, which yes, it has a whole bunch of schedules and additional questions and everything else, but foundationally, it still is reporting out your financials at the end of the day.
Because a 1099 is also an informational return, but you can't compare a 1099 to a 990. It's completely different.
Apples and oranges, both fruits, but apples and oranges. But this actually brings up a really good point that the big firms have lawyers and accountants, and so they can kind of have that holistic, non-siloed advice that they provide to their clients. It's a lot tougher when you aren't big accounting firms or big law firms, where you've got law firms and then you've got accounting firms, and you have those kind of siloed expertise or knowledge base. And you have made a step in the direction of combining those. You kind of mentioned it before, but I'd like to go a little bit more in depth. And so have I with my practice. I'm not in Arizona, so I can't, kind of utilize the alternative business structure that you might tell us a little bit about. But we are bringing an accounting firm and a law firm together to talk and not silo the information that our clients have. A perfect example, we were talking about the 990, it asks if you've made any changes to your governing documents, or, why you might have made changes to your governing documents. And a lot of accountants, if they're just doing tax preparation, might not know anything about that, but a law firm would. And if you have some kind of, information sharing between the lawyers and the accountants, it only benefits clients. Maybe you can tell me a little bit about why you made the decision to kind of combine those, besides having a CPA and a JD on your
resume. Yeah, so you position that perfectly. What happened, awkward position that we put clients in is really unfair to them, where they have to be the ones that are translating information they get from their lawyer to their accountant.
And vice versa.
And vice versa,
yeah.
Because they're good at running nonprofits, fundraising, explaining their mission, their programs, and administering these things, that they don't have the technical expertise. That's why they hire us. And so to put a client in that position where they have to be the interpreter is really unfair and awkward for them. And frankly, information gets missed. And so, but the problem is there's no financial incentive for accountants and lawyers to work together, because clients don't want to pay for a back office meeting between an accountant and a lawyer. They're like, you guys should know this stuff. And every lawyer is going to bill, accountants maybe are more moving to flat fee billing and subscription billing, but lawyers for the most part are still on hourly billing. And so then the other alternative is that we have three of us in a room, the accountant, lawyer, and the client, and they're being double billed for the time.
Mm-hmm.
And so what you're doing and what we're doing is essentially combining in-house the accountants and lawyers, so we can have back office conversations, we can share notes, we can share files, and the accountants can go in and see the legal documents. And we obviously, clients got to provide permission for all that, and then lawyers can review the tax forms, and they can get the information they need without having to go through this formal consent process, without having to have the client be the middleman and explain, here's the good example that, and it was one of the driving reasons that I decided to go out on my own was I was doing 990s at EY, and I was doing 1023s as well. So exemption applications.
Mm-hmm.
I would have to send that out to a lawyer every time because we couldn't draft the governing documents there. We couldn't draft the bylaws, conflict of interest policy, couldn't draft the articles. I would get these back and they were wrong, right? They didn't have the right language in there.
Mm-hmm.
And so I decided I can do both of these for my firm at an expert level, and I don't need to send it back and forth. We can do the full legal documents, accounting documents, IRS application, get it all in there together, and we don't have to have a middleman anymore. And so that was kind of the vision, and that's we eventually expanded to working with for-profits as well. I added a business partner who's more of a tax planning person.
Mm-hmm.
I've got the nonprofit expertise, and so together we're able to benefit nonprofits because we can speak 990T, for-profit, kind of corporate law, corporate tax law, and then on the other side, we understand the legal side that goes into it. So it works out really well.
Well, it's so unique. I haven't found many people besides you and myself and maybe one or two others that can, the language that comes out of a CPA and the language that comes out of an attorney, it's just that you're taught to think differently. You're taught to analyze things differently. And so you're going to get issues if you don't kind of meld the two, at least in my opinion. I think lawyers need to understand financial and accounting and restricted funds and everything else that is typically in the wheelhouse of an accountant, but also vice versa. So, you mentioned where, you sent it off to the attorneys and it came back wrong. I've had the exact same thing happen with accountants. We craft everything, they send it. And I also think it's, you're unique somewhat in that you truly understand exempt orgs and then you added business. There are so many accounting firms out there that are business focused, or at least they came about with a business focus, and then they just added nonprofits or exempt orgs to it. And it's, in my experience, I don't think that works out really often. If you just kind of append it, you have to have a deep understanding of why exempt organizations are so different from businesses.
Yeah, I tell practitioners all the time. I've even posted about this on LinkedIn a few times because it's so critical. You cannot dabble in nonprofits. You really can't. As a practitioner, you will commit malpractice if you're just doing this on the side to help somebody out. And I actually have a friend who owns a CPA firm who was trying to do this. He was trying to do his own, clients. They just, it was kind of a convenience for them. And this is how it normally happens. Somebody that's a good client for you, from a tax side, for example, sits on the board of a nonprofit, and they're like, "Hey, you're a CPA. You can do this form, right? It's a tax form." And so the CPA is like, "How hard can it be? I know how to do forms with the IRS. So I'll have the instructions available, and I'll just follow the prior year." Well, something changed within the organization's activities, mission, et cetera, that would have triggered a new form to be filed, or would have changed the way they responded, or answered the public support test, whatever. Mm-hmm. And it doesn't get picked up because they don't really understand what they're doing. They're kind of just filling out a form. And so my advice on to the practitioners, I know that's not necessarily your audience, but is just don't dabble. If you don't know nonprofit law, don't do it. And we've taken the same approach with other practice areas. IRS resolution, for example, I've pulled all of my tax managers off of any sort of IRS correspondence. I have one contractor who that's all she does, because it's a completely different skill set. IRS procedure is completely different than tax planning and tax prep. And 100%. So you just leave, nonprofit is a specialty, should not be dabbled with. because when you miss something, if it's important enough, you could lose your exemption or you could be penalized. And one thing that people don't understand is that with nonprofits, unlike corporations and LLCs, which generally have limited liability, nonprofit executives, directors can be personally fined with excise taxes.
Absolutely.
And that's a risk that you can't really afford for, your philanthropic efforts. It's disproportionate to that. And you really need to get good counsel on this.
Absolutely. Now you spoke about it going one way. I'm going to speak about it the other way. Lawyers are the same thing. They should not dabble in this because, I just had a new client sign a couple of days ago who had a pro bono attorney who dabbles a little in it, set them up as a C4, which is the right thing, but foundationally, she started with the wrong articles. And in California, if you start with the wrong articles, it can create a lot of problems because you're not allowed to easily, unlike businesses, you have to go through the attorney general in order to get a waiver to even change. I think New York has, provisions like this too. It used to be you had to go to court to do things like that. But it's from the very first filing, articles of incorporation, it was set up incorrectly. So now we have to go back and get a permission from the attorney general to change it, then go change it, and then go forward. And the attorney general in California, I don't know if you practice much in California, they are delayed like 11 months. Some of these requests that we're submitting are taking over a year for them to process. So it's not something that can easily be fixed.
Yeah, absolutely. In California, there's several agencies specifically that, you're governed by as a nonprofit. And so such an important lesson is you've got to have your foundation in place. And you can't, as a practitioner, as a lawyer or accountant, you can't figure this out as you go. If you don't know it, you don't know it. Learn on your own time. Don't learn at the client's expense. I think the perception in our industry is you have been exposed to certainly so many times is these are nonprofits, so therefore we should work on a pro bono basis. And that happens a lot. And I'm all for providing pro bono services where appropriate, but when you're in a complex nonprofit or organization, you want to pay for the right advice. You don't want to get the free advice that's going to later cause you to pay taxes, be fined, lose your exemption, because it just causes so many more problems.
Right. Well, and I think it's a common, well, it's not even really a misconception. I think it's just a pervasive feeling of practitioners and professionals of all types. We want to give back to our community. We want to help that nonprofit. We want to. So if I were not at practicing exempt or nonprofit attorney, and I was this kind of takes me back. I was an intellectual property attorney in-house, doing patents and trademarks, and got asked to form my first nonprofit pro bono. And I did. Should I have? I don't know.
Hopefully,
but I did a great job. But to your point, it's fine if you're willing to put in the time and effort to really master it. And that luckily I did master that. And we were very, very successful, multi-million-dollar grants and did a lot of great work. But if you have a full-time job doing another practice area and you just want to do it as a one-off and you're not willing to put in that time, I would steer them away from it too. I think it's a very good point. So you've mentioned a couple of, potential issues: loss of tax-exempt status, excise taxes, intermediate sanctions. So what are some of the top things that you would recommend to organizations to kind of avoid that besides engaging a dabbler?
Yeah, the IRS puts out a lot of good information, and there really is a pretty good research library out there. Even before AI existed, there was a lot of information online. There's different courses you can take. What I recommend for board members is that they take a crash course in, I can't name one off the top of my head, but there's several out there that are kind of like 1 to 2 day, what you need to know from a governance perspective as a board member. I always recommend that be part of the required board training. The other thing I recommend is that nonprofits, especially when we're talking about some of the smaller ones like PTOs and booster clubs, where there's a lot of turnover, because, typically with those organizations, when the kid graduates, the parent's not going to serve on the board anymore. And so what you see is there's turnover, and historical information doesn't get passed on from one board generation to another. And so I recommend they have some sort of nonprofit practitioner, and it doesn't really matter if it's a lawyer or accountant. Somebody's got to be there to bridge the gap and to help ensure continuity. And so I recommend our nonprofits put together a board packet, and, used to do that physically. Digitally now it is even better. You can basically create a shared file room online where all of the governing documents are stored, and then put together required training for new board members, including not only general nonprofit principles, but also for this specific organization, you're required to read through the articles, read through the bylaws, read through our budget, and then sign off that you've done each of those things. And you're not going to get a vote, and you're not going to get voted on until that homework has been done.
That's actually really unique, especially the bylaws. It surprises me still how many organizations or new board members come on to a nonprofit or board and say, "Oh yeah, we have to follow Robert's rules." For example, I just had another one the other day. That's why it's occurring to me. And it's like, well, is an adoption of Robert's rules in your bylaws? Well, I don't know. And it's okay. Those are two vastly different, ways of organizing and governing an organization. You can put some of it together, but they can be conflicting. So you better know how your organization is chartered and set up to run. And bylaws, I do say they're probably one of the best insomnia cures of all time. But it is something that every director needs to know. But I will also say it's also something that every organization needs to have
what happened
an attorney review on a regular basis. It doesn't need to be every year or anything, but on a regular basis, because, there are provisions that I see don't make it into nonprofit bylaws that must be there, or you get the statutory default, for example, and no one is going to go look up the statute to find out if you're doing things correctly until you've got board conflict. And that's the absolute last time you should discover that there are missing provisions in your bylaws. So I recommend anywhere, I'd say about 3 years, every 3 years, it should come up for a review. Are you about the same on that recommendation?
Yeah, similar. Yeah, exactly. Every few years, just have them looked at, make sure that they are current, make sure they are in line with what you're actually doing as a board. And there's no problem with changing your bylaws to match what you're actually doing. But one thing I see from time to time is an organization votes as a board, they see an opportunity, right? And a lot of times board members are business owners. And so when they see opportunities, they go for it, a new revenue stream, for example, or new activity. And so they vote as a board to start conducting a new activity. Well, what they don't realize is that activity is not considered, in one of their charitable purposes. And so now they start doing something that doesn't line up with their charitable purposes. And, IRS potentially could look at that, whether when reviewing your 990 or on audit, and say, you're acting outside of your charitable purpose. That is a charitable purpose, but it's not allowed to do that according to your bylaws. And so it's a simple fix. You can amend the bylaws. The board has the power to do that anytime. You just need to make sure that what you say you're doing and what you're doing are matching.
Right. And it's not just your bylaws, it's your articles of incorporation as well. I discussed this with Gene Takagi in one of my previous podcast episodes. The state of California, the Attorney General actually says you do that and you're acting outside of your total purpose. So it has nothing, it's misuse of charitable assets because you didn't do it correctly. It all comes down to truly understanding what your articles say and making sure that they are in parallel with your bylaws and your bylaws are in parallel with how you are actually operating. I couldn't agree more. But every board member needs to truly understand that.
And the other thing that we always say the ABCs of forming a nonprofit. You get the articles, the bylaws, and the conflict of interest policy, right? Mm-hmm. I think the conflict of interest policy is underutilized and not reviewed enough. Because now we're not just talking about, what goes on in the board meeting. We're talking about what goes on in your personal life. is going to, potentially affect the organization. And so that's something that is critical. Every board member needs to understand that conflict of interest policy. They need to understand what transactions they can and can't do, or which ones they can do, but just have to be disclosed.
Right. In our practice, we have our conflict of interest policy, and then we have an annual disclosure that every director is required to review the policy, disclose anything, sign it, and it's kept as part of, the minutes of the meeting or of the annual meeting. And you're right. Most organizations, we have a policy. We can check that box, right, on the 990, but do they actually implement it in practice? Do they actually abide by it? And it differentiates the well-run organizations from the poorly run organizations, in my opinion.
Yeah, I like that you added a D. So now it's ABCD, the disclosure.
Disclosure. Yeah, there we go. Well, that's a great place to kind of wrap this up. Is there anything else that you would like to share with anyone who's listening to this podcast?
I just, as a general principle, and these are things that should be reviewed. Everything that you do has to be fair to the organization, either at market value or favorable to the organization. I just see this so many times where people think they own the nonprofit and therefore they can pay themselves any compensation they want. They can get into whatever transactions they want. And those are some of the biggest red flags the IRS will look for. And so just make sure that you're getting good counsel, that you're reviewing your documents, and that you're being fair or favor, generous to the organization.
Absolutely. That's a great final tip. Well, thank you so much, Mike, for joining me. It's been a real pleasure to have you on the podcast.
Thank you for having me, May.
Thank you for listening to the Nonprofit Counsel podcast. Are you ready to lead with clarity and confidence? Head to nonprofitcounsel.com to find the tools you need to start smart, lead strong, and create lasting impact.